I'm Colin O'Keefe, and I'm joined by Jared Sulzdorf. We're a couple of your editors on LXBN, and this is LXBN This Week, as we take a look back at a couple of the most talked about stories on the Lex Blog Network over the past few days. Jared, starting off, what were your thoughts on the coverage? It seemed like it was a very busy week with a number of subjects seeing a lot of commentary.
Yeah, absolutely. It was a good week in terms of just the diversity of coverage. We had Brinker v. Superior Court finally have a decision. We had a decision come down Chamber of Commerce v. NLRB, which kind of changed the landscape on a couple of things. Then there was some news in hydraulic fracturing, and this week kind of wrapped up with you doing an interview with Josh Alloy on the recent decision in Christopher v. SmithKline. So just a busy week and a lot of really different coverage.
Yeah, there was a lot going on, and something that I randomly thought of, even though there was a ton of coverage, no trending privacy stories this week. That never happens.
Yeah.
But jumping into things, first off, we have Brinker v. Superior Court. This was a case that was decided last week in the California Supreme Court, and then we saw a lot of reaction this week on the case. The case has to do with meal and rest periods. Brinker Corp is a company that manages a number of restaurants, including Chili's is one of the restaurants that I believe that they manage down there. And at the crux of this case is our meal and rest periods for employees, and the decision was that employers, while they do have to provide meal and rest periods for their employees, they don't have to absolutely make certain that they're taking them. They don't have to follow these people around, make sure they're prodding them and making sure that they're taking these. Doing enough to provide them, making sure that they're aware of them, is good enough. But Jared, what are your thoughts on the coverage? Who do you think covered this story exceptionally well?
Well, we just had a ton of coverage on it. I actually got the chance to write a piece on it, so I really looked at the coverage in depth. And you're right, it is kind of a funny case. I think I mentioned actually what restaurant employee isn't looking to take a cigarette break, yeah. So it was kind of funny. But we had 28 overall new posts with coverage with the decision coming down on Thursday, I think, and just kind of stretching out into the week, and 4 pages total just on Brinker v. Superior Court. It's been going on for 5 years, so there's just a ton of information on it. And my favorite post actually came from Elizabeth Arce, who is an attorney with Lieber Cassidy Whitmore, and she had a really nice, informative post that was also really succinct, so it didn't just drag on and on and on, and she gave an overview of each pertinent point, so it was really good to see that, and that was on the California Public Agency Labor and Employment Blog. But yeah, just a ton of coverage overall on Brinker.
Yeah, definitely. And I actually got a chance to speak with Thomas Kaufman of Shepherd Mullen and their Labor and Employment blog, and he, we talked, for a bit about that case, and that will actually appear on Monday's episode of LXBN TV. So be sure to watch out for that as he joins us to talk about that. And Brinker, it's been a very talked about case, and of course, employment law is always a popular subject, but this case was actually overshadowed by another employment law story on the network, and it's one we've been tracking for a while. Jared and I will crack jokes about it occasionally because it all comes down to a poster. It's the NLRB posting rule story, which is the NLRB created a rule. It goes back a ways. It's been fought over constantly. The NLRB wants certain employers to post a poster stating their rights under the National Labor Relations Act. And getting into the nitty-gritty details of it, the U.S. District Court for the District Court of South Carolina struck down the poster rule, saying that the NLRB doesn't have the right to create rules like this under the National Labor Relations Act. Then you have the U.S. Court of Appeals for the District Circuit then issued an order blocking the rule from going into effect until they can rule on it. But this comes right after they had ruled saying that the NLRB has permission to create these types of rules. So it's very, very interesting. It's all over the place. Ultimately, I don't think people are as upset about the poster. They're upset about the fact that if they don't hang it, it's considered an unfair labor practice. And in my interview with Seth Borden, he said that normally the NLRB is a very reactionary agency. They'll get all pissed off if somebody fires somebody for posting something on Facebook, but normally they're not the type of person to create rules and to go into creating situations where people can get in trouble. But Jared, what are your thoughts on the coverage? Obviously this story has been covered for a long time and it really exploded this week.
Yeah, it did really explode this week. It's kind of interesting to watch how posts come in and filter in. It just seemed like it was wave after wave after wave of posts. We have in the neighborhood of 150 posts on LXBN that are curated and tagged just for the NLRB, and 74 or 5 of those, so half of it, is just on this NLRB posting rule. So it's just a huge topic. And within that, there's this subset of the Chamber of Commerce, the NLRB stuff, which came out this week. and that was some 36 or 37 posts. So just a ton of coverage. And you mentioned you did an interview with Seth Borden, and Seth Borden probably covered it the best. It's really difficult to find people that have covered it the best. It's like a needle in the haystack when you're looking through all of these posts and you're trying to pick somebody out. But he did a great job of that.
Yeah, Seth Borden, also Green Bay Packers fan, so he gets some special favor from me, though not from Jared for being a Vikings fan. The other story, following up on the NLRB posting rule, we get out of employment law a little bit, and we get into a subject that's really not just been covered in the law a lot lately, like you see with the NLRB posting rule, but one that's been covered by the national media a lot lately, and that subject is hydraulic fracturing, or fracking as it's often called. This story was covered, a number of ways. First off, we had President Obama issuing an executive order to create what's called an interagency work group, as our bloggers described it, to take a look at how fracking is regulated and what's going on there. Also, we have the EPA issuing rules not just for polluting groundwater, which has been often the biggest issue with hydraulic fracturing, but also the air pollution involved. The EPA has taken a lot of interest in that as of late, and they issued some rules there this week. And then finally, the biggest issue with hydraulic fracturing, and I think where people are most concerned, is does this cause earthquakes? Because, pollution is bad enough, but if this is something where we're doing something that's creating artificial natural disasters, that paradox there, that's bad news. And there was actually a report coming out of the UK done by the government there where two seismic incidents were attributed to hydraulic fracturing. So it's very interesting to watch, and we have a lot of people covering it well. Jared, who do you think covered it the best?
Well, there were a number of different people this week that kind of chimed in on everything that was going on, and Keith Hall, actually over on the oil gas law brief, was the first one to come in with that little post on the UK government study, like you mentioned. It's fascinating to see that something that we're doing for natural gas could actually cause earthquakes, but, that's just something that they'll figure out as it goes on. But he kind of kicked things off, and it was fascinating to see that right after that, more posts came in on the EPA rule and President Obama and his rule, and we just have a lot of posts on hydraulic fracturing in general on LXBN. It's one of the powers of tagging, I think, in LXBN, which is that we get to group all of these things together and see the EPA rules and President Obama's executive order, along with a scientific study, all under this umbrella of hydraulic fracturing. And there's some 4 pages there of information.
Yeah, we had a lot of our environmental blogs cover it, energy blogs, and we have a couple blogs, Keith Hall's being one of them, that's almost devoted directly to fracking. We have a couple people, Eric Wackerlin, fellow University of Montana grad. He went to law school there. He covers this. He has a fracking publication with Kelly Dry. But yeah, Keith Hall has been exceptional in covering these stories. He's somebody who's come on LXBN TV twice previously, and I'm sure before long we'll have him on again. But yeah, keep an eye on fracking. That's a very popular subject, and this isn't going away. This is not a new way to produce news, or only some people are obtaining natural gas and oil from hydraulic fracturing. This is everyone who's looking to use hydraulic fracturing to get this natural gas out of rocks.
Absolutely.
And then finally, we get away from that a little bit. We wrap things up with Christopher v. SmithKline Beecher Corp, which is also GlaxoSmithKline, a case that came before the United States Supreme Court this week, and oral arguments took place there. At the crux of the argument there is whether or not pharmaceutical sales representatives are exempt from overtime pay, because under our nation's wage and hour laws, what are called outside sales representatives are exempt from overtime pay. But the interesting thing about pharmaceutical sales reps is they don't sell anything. They're not allowed to legally sell medicine to people, so it's worth considering, well, they're actually salesmen because they're not selling anything. They do a lot of things, but they don't sell. Jared, what are your thoughts on of course, as I mentioned, we had the LXBN TV, but do you see anybody who covered this well? We have a lot of posts on it.
We did have a lot of posts on it. Once again, it's difficult to pick somebody out in particular that did a really good job. I know you interviewed Josh Alloy. He's done a really good job covering it. But this is one of those cases actually where when I was looking over it, I was kind of surprised at just how long we discussed cases like this. The Supreme Court took this case up a while ago, and I did a roundtable on it, I think sometime in November. and they're just kind of coming down on a verdict. And so it's interesting once again to kind of watch things go along there. But overall, I would say the network coverage is just really thorough in this one. Maybe not quite as dense as it is Rule or Brinker, but it's just thorough. Kevin LaCroix actually did another really long post on it, and he's just somebody that once he gets something in his teeth, he just goes down.
Yeah, seriously. But we love Kevin LaCroix. It's like, how does he write so much? But yeah, also I think the fact this is a story. The oral arguments just took place this week. A lot of time it takes a couple of days for things to kind of churn through. But Josh Alloway got right to it. He was writing right on the oral arguments as soon as they came out. That's why I was sure to reach out to him with an LXBN TV interview, and I thought it turned out great. But that's all we have this week for This Week in LXBN. It's been a great week, and oddly, yeah, no privacy stories, but unsurprisingly, a couple employment law stories. We have tons of great employment law publications. But be sure to watch we have a couple good LXBN TVs coming up next week. I look to hit the Maryland Facebook law. We're also going to be talking about Roger Clemens. As I mentioned, we had, and we're going to have Thomas Kaufman come on to discuss Brinker. So be sure to check those out. It's going to be a good week again on LXBN. We look forward to seeing some more good coverage.